Hey, California residential landlords, what you don't know can hurt you. Do you know if you fall under California rent control, or do you fall under one of the exceptions? Did you know that if you fall under the TPA that you might be stuck with a tenant for as long as you own the property? If you rent out a single-family residence, did you know that failing to give your tenant a simple one-page notice can put you under rent control? Well, watch this video to find out about this and more.
Welcome to Rock Real Estate with Stu Simone, where we make real estate informative and fun. And now, here's your associate broker, real estate attorney, and mortgage loan originator, Stu Simone.
Hello and welcome to our video about California state rent control, the California Tenant Protection Act of 2019, which was created by Assembly Bill 1482. In this video, we will discuss how this law was instituted, what it covers, and what it does not cover. We will also discuss some of the specific provisions of the law, such as rent increase limits, just cause to evict, no fault and at-fault reasons for evictions, and landlords noticing requirements. Now for a little background. On October 7, 2019, California Governor Gavin Newsom signed Assembly Bill 1482, or AB 1482, which aimed to give Golden State residents relief from soaring rents and home prices by instituting rent control across the entire state. This was in response to the concern of many Californians that they would not be able to afford their rent payments, which was confirmed in a survey conducted by the Public Policy Institute of California. Okay, let's get to it. Coverage and exemptions. AB 1482, or the TPA, affects about 2.4 million homes and apartments and is in force until 2030. Important considerations for real estate investors are that this state rent control, 1, institute limits on how often and how much rent can be increased, and 2, requires that property owners have just cause to evict a tenant. In other words, as long as the tenant is following the terms of your lease, a landlord cannot make the move out. However, there are AB 1482 exemptions. Units constructed in the last 15 years are exempt on a rolling basis. Units are exempt if they are restricted to be affordable or low to moderate income residents. A single-family home is exempt unless it's owned by a real estate investment trust, a REIT, a corporation, or an LLC where one of the members is a corporation. So be careful if you have an LLC. Duplexes and other two-unit properties are exempt unless one unit is occupied by the owner. This is to protect homeowners who build and rent out an ADU. Some dormitories are also exempt. Now, what's just cause to evict? Landlords cannot make a tenant move out without just cause. All the following would qualify as a just cause to evict a renter under the Tenant Protection Act. Non-payment of rent, which is an at-fault reason. The owner moving themselves or a family member into the unit, which is a no-fault reason. The owner substantially renovating, that's also no fault. The owner going out of business, also no fault. These are all at-fault reasons. A breach of material term of the lease. Nuisance, waste, unlawful or criminal activity. Refusal by the tenant to sign a written extension or renewal of the lease. Refusal by the tenant to allow the owner to enter the unit, and assigning or subletting without the landlord's approval. However, rental properties that are already subject to a local ordinance that requires just cause to terminate a tenancy and is more protective than state law are exempted from the just cause regulations. LA, I'm talking to you. Single-family primary residences of the owner where the owner rents no more than 2 bedrooms or units, including accessory dwelling units and junior accessory dwelling units, and accommodations in which the tenant shares a bathroom or kitchen with the owner are also exempt. Now let's talk about eviction provisions. The eviction provisions of the TPA apply only after A, all tenants have lived in the unit for 1 year or more, or if B, at least one tenant has occupied the unit for 2 years. Tenancy may not be terminated without just cause, which must be stated in the termination notice. As mentioned above, just cause reasons are categorized as at fault and no fault. This is an important distinction because relocation assistance is required in the case of no fault evictions. The mere expiration of a lease or rental agreement is not just cause. Thus, a California landlord had better like the tenant he takes, because he could be taken in for life. Now let's talk about rent increase limits and exceptions under the TPA. All right, it's that time again, investors. Math time. For covered units, annual rent increases are limited to no more than 5% plus the percentage change in the cost of living for the region in which the property is located, or 10%, whichever is lower. The percentage change in the cost of living is calculated using the Consumer Price Index for all urban consumers for all items for the metropolitan area in which the property is located, as published by the United States Bureau of Labor Statistics. For regional index is not available, the CPI index for all urban consumers for all items as determined by the Department of Industrial Relations shall apply. Well, the math gets even more complex in some instances, so if you're interested in that, check out the full blog article on rockrealestate.org if you're interested. Now, it's important to note that there can be no more than 2 increases in a 12-month period, and the combined amount of rent increase cannot exceed the 5% plus CPI cap. Now, there is no limit on the initial rent charged for a vacant unit. Notices that landlords are required to give under the TPA. All tenants in units covered by the state law must receive a notice explaining the just cause and rent cap provisions. For any tenancy commenced or renewed on or after July 1st, 2020, the notice must be provided as an addendum to the lease or rental agreement, or as a written notice signed by the tenant with a copy provided to the tenant. Property owners must communicate with tenants and how violations of AB 1482 are enforced. The notice must contain specific language that states that California law limits the amount a rent can be increased, and that a landlord must provide a statement of cause in any notice to terminate a tenancy. If a property owner claims an exemption because the property is a single-family home or condominium, they must provide a written notice to the resident. If the owner fails to provide this written notice, then the property is not exempt from the just cause or rent cap regulations. So this is really important, that notice. Enforcement of the TPA AB 1482 can only be enforced in state court, and although no penalties are listed in the law itself, residents can sue for damages for wrongful eviction or unlawful business practices based on violations of the TPA. So, in conclusion, if you are a property owner in California, it's essential to understand your obligations under the rental law, specifically the Tenant Protection Act of 2019. Communicating with your tenants is a critical aspect of compliance with the law, and failure to do so can result in legal action. Understanding how violations of the TPA are enforced is also important to ensure that you are complying with the law and avoiding potential legal issues. So, I hope you enjoyed watching this video, and I'd appreciate any comments you may have. Again, this is Stu Simone with Rock Real Estate, and be sure to hit the like and follow for more right here. And coming soon on Stu Simone Real Estate right here on YouTube, should you hold your real estate in a trust?